Okay, doctors, welcome to today's program. My name is Dr. Cronk, and I'm the CEO of Spinal Kinetics. I'm also the founder of the Smart Injury Doctors Program, and I'm very, very, very excited today to have with me a special guest, attorney Mark Blane. I've wanted to have Mark on a program like this for a very, very long time. I'm going to show you a video. I want to show you a video of Mark. This is his website out at blanelaw.com, and I think this kind of summates Mark as an attorney. So I want to play this first.
Not every case is going to need a lawyer, but every case needs good legal counsel. I'm not only a settlement lawyer, but I'm also a trial lawyer. I have the ability to stand in front of a jury and ask for justice, especially on an injury case. I know what people are going through. They're scared. There's a lot of fear. I can alleviate that fear. Talking to them about their injuries, just talking to someone about what they're going through as a person. So not only am I getting my clients better, getting legal remedies that you're entitled to under the law, but we're also making the community safer, one step at a time, one case at a time. It protects all of us in the end. I know I'm going to be able to do a good job for that. It's really inspiring for me to pursue this career.
Good. So I wanted to play that. So you're going to get a feel for Mark Blane now. I'm also going to share with you that he wrote a book, and I apologize for the graphic here. I realized when we blew it up, it's a little bit unclear, but it's very easy to see. He wrote, as far as I'm concerned, the most definitive, easiest book on injury documentation that I've ever read. And I've read a lot of books. This should be required reading for any attorney or any doctor that does any kind of personal injury work. And it applies. You're going to see a graphic over here where it says, hey, look, motor vehicle injuries are this size of the market. Work injuries are this size. Home injuries are this size. Public injuries, that's things that occur outside of the home, not in a motor vehicle and not at work. And when it comes to injury work, it doesn't matter if you read Mark's book. The basics of injury documentation are in this book. That's why I'm so excited. I've promoted this book ever since I saw that he wrote it. I've been promoting it. We promote it as a company that people should read it, not because you want to take unfair advantage of anybody. One of the things in personal injury that I actually have experienced for myself is that the more you understand sort of the rules of the game and the more you play by the rules of the game, the easier it is to play the game. And it's just that easy. So with no further ado, Mark, I welcome you. Thank you so much for taking time. I know you got a busy practice in San Diego, for taking the time. And I guess how I'd like to start off is just, you know, for our public to get a little bit of feel for you. Why did you become an attorney? I mean, when you were in 5th grade and said, look, I want to be an attorney, or how did it work?
Well, yeah, thank you, Dr. Cronk, for that introduction, and thanks for the invite and everything. But yeah, I became a lawyer because I grew up in Louisiana, and so my mom was working for a law firm, or sole practitioner, personal injury lawyer, and I thought it was just the coolest job in the world. I always enjoyed science and biology and anatomy, and this allowed me to kind of pursue that passion with the legal field. And so when I was a little kid, about 11 years old, I already knew I wanted to be a lawyer. So I was kind of one of the lucky ones in terms of what I wanted to do. So I think that was the why I became a lawyer and why I do this area.
Absolutely. Okay, so the next question I have for you is, first of all, I'm going to tell you that it's amazing that you wrote. I mean, this is not the only book that Mark has written. Mark, how many books have you written?
I think it's 10 books today, but it's just all related to either injuries or your case and legal process and that type of thing.
Right, which is amazing to me because, one, you're taking the time to educate people and educate the public, educate the doctors, educate the insurers, educate anybody that wants to pick up this book and read it. And it takes a lot of work to write a book. I mean, it doesn't take a lot of work to get the idea to write a book. It takes a lot of that work to get a book written and then get it published and produced. So as I said, this is the best book that I have ever read because it's logical, it's in order, it's comprehensive, but yet it's simple. But my question is, why did you write the book?
Well, that's an interesting story. As I started out as a personal injury lawyer, I noticed that the value for the needle to move on the value was through documentation of the doctors. And as I explored that further, I started noticing that there are certain injuries that took more value. And when it came to a muscle injury or a ligament instability injury, the value went up exponentially. And so I'm starting my practice. I'm trying to do the best job I can do for my client. And so by learning about ligament injuries and how to document them for impairment, it was just going off the charts in terms of value. So I knew I had something, and I wanted to communicate it to the doctors that in my locality, because I wanted to communicate this powerful information. And that was it was a love of labor. This was really the reason why I wrote the book, is because then I can meet with the doctors that I'm working with and say, look, maybe you can just take it and read it when you have 15 minutes time off, and instead of me sitting there, telling you what it is, you read it when it's on your time. And so that was the big impetus for me to write it and the passion behind it. So
absolutely. Yeah. Now, I guess the question is that now that you're 10 years after post writing this book, right?
Yeah, I think 9 years, 10 years, yeah.
10 years, 9 years, 10 years. Okay. Yeah. So what I've said to attorneys for a long time is that there are going to be times, and this is where you understand what's needed in an injury workup sometimes better than the doctor does. And sometimes that's hard for an attorney, because all of a sudden you're saying, it's like me going to an attorney and saying, well, here's how to run your case, right? It's kind of a touchy
Yeah.
thing. So how have you navigated the fact that you can work with a doctor, start to work with a doctor, or I guess even better, what do you look for in a doctor? But when you're starting to work for a doctor and you feel like that doctor maybe is not understanding exactly how injuries should be worked up, how do you address that with the doctor?
Yeah, so and that doesn't happen too often, but every now and then it does. And so I just say, look, I just tell them from my perspective, my experience, that a ligament injury, instability injury, when documented appropriately, really protects value on the case, and that's good for everybody. And so I can approach it gingerly in that regard, but it is definitely something that I'm always looking out for. And when I get involved in a case and there's a doctor treating it, I'm not too familiar with the doctor, I'll reach out to that doctor and say, hey, this is what I've found to be very helpful. And from the front lines as an injury lawyer perspective, not so much a doctor perspective, because I'm not a doctor, but
Yes.
that tends to be, and they don't hear that a lot, so that tends to be very open. And I get a lot of positive feedback with that, and then they'll open up, and sometimes we'll just meet, especially with COVID now, it's more Zoom, right?
Yeah.
But,
yeah.
sometimes we'll meet, and I'll shoot them some snippets from the book in terms of what I'm looking for and what I find to be really proactive to be prepared for the case, and that tends to be okay.
Okay, good. All right. So what you said, obviously, I'm a guy. I started 2 ligament testing companies as a doctor of chiropractic for 17 years. I realized the ligament injuries were the most common cause of chronic pain. They're the most expensive injuries. They used to be thought of as just a soft tissue injury, which always, your eye is a soft tissue, your heart is a soft tissue, your brain's a soft. I mean, all the crucial tissues are soft.
Yes.
So, I never understood the whole idea of it's just a soft tissue injury. And so, the fact that you align so much, matter of fact, you align so much with a soft tissue injury that you dedicated a whole chapter 10 on loss of motion segment integrity, which is an aspect of excessive motion. Tell us a little bit about, from an attorney point of view, how did you get that? Because the doctors that are listening right now, the biggest struggle that they have is getting an attorney to get that, to understand that.
Yeah, no, that's a challenge. And that is that's a very common question I've had over the years. How does the doctor communicate because really a doctor and an injury lawyer is a power relationship in terms of the case. How do you communicate that to the doctor or to the attorney and the doctor to work together? You know, how can I say this? I mean, we have weak backs. I mean, the posterior chain of our bodies are as weak as they've ever been. And when you get in a car crash or any type of injury producing event, it's important that gets documented and that both the doctor and the attorney work together and know that that's the important injury that needs to be documented. Obviously, if you have a surgery case, it's a no-brainer. You know, that's one thing. But this book, this book on chapter 10, lost motion segment integrity, that is the anchor to really releasing the value of a soft tissue case. I would say lost motion segment integrity is the king of the injuries if it's properly documented, and it's a 1-2 punch, as I say in the book, because not only do you have to document it, but you also have to use it as an offensive motion in the AMA impairment. So how do you line all that up? That is a challenge, you know, and I even get challenged communicating this information to my colleagues sometimes. I'll get a glazed overlook in the eyes. You know, there's different perspectives and different skill and experiences out there with both doctors and attorneys. But it's just something that the doctor is going to have to be proactive on, as well as the attorney, and to find each other in your local community and match up. Pick up the phone, call the attorney and say, hey, let me tell you what sets me apart a little bit different from all the other doctors. I'm really good with soft tissue cases because I focus on ligament instability. Why is that important? Because, hey, you can even use the book and say, look, there's an attorney out in San Diego. He uses it and he's got some success. And that could be a good intro. I don't know. Just trying to think off the top of my head here.
That's great, because for years, that's one of the things I promoted in my educational programs, is just send a copy of the book. Buy the book, send a copy of the book. Today, it's downloadable on Amazon. You just go out and download it to your Kindle, have your attorney download it to the Kindle, and read it.
Yeah, it's a confirmation bias. There's other people doing it. Here's some evidence of it. Here's this. And so that would be helpful. But it's an art to it, because both the doctor and the attorney have to be on the same page to some degree, because really I become the voice of your chart notes throughout the case. You become, as a doctor, the voice of your own chart notes when you're deposed and in trial. So it flips, and the dynamic flips in that regard. So you want to find someone who's like-minded, who understands that the posterior chain of the back is weak and it can get really destroyed in any type of car crash, whether it's a low impact or especially high impact, and then know why it's important and why it needs to be documented very specifically, because that's what the computer programs are going to do. But also beyond the computer programs, you're going to want this for trial or mediation. So by doing this very detailed work, you're setting up the case for a very good outcome to get for the patient, which is the ultimate goal, by just coalescing all this information and working synergistically with the lawyer with doctor with lawyer.
Right. Well, wouldn't you say it's true too? Because I've said this also for years, and I've experienced it for myself. The more the doctor understands the injuries that they're dealing with, the significance, the severity, location, the consensus behind what the injury represents, the easier it is in deposition. The less antagonistic and the less adversarial the deposition becomes, because you're laying out just objectivity, that if the defense attorney or somebody wants to argue, they're arguing with the AMA or they're arguing with consensus. And they don't even really have to argue with the doctor, because the doctor is just presenting the consensus. Would you agree? Right.
Absolutely. And that makes it very smooth in deposition, trial testimony, or even reading the chart notes. And it's a very non-adversarial way of presenting the injury itself, and why it caused pain and discomfort so long. Because on a soft tissue case, you always have that mantra from the defense, 2 to 3 months is typical range of injury. But if you're getting into ligament instability, something moving beyond muscle that touches bone, ligament, or nerve, it explains objectively, like you're saying, the consensus as to why the patient treated 6 months or longer, or whatever the case is. And
Right.
once you have a ligament, and you know this, once the ligament is compromised, it's okay to get further diagnostics. It's okay to get further chiropractic or physical therapy. It's okay to do a lot of other exploring, as opposed to not having that documented, and now it's just a muscle tissue case, which is a very different value. And so that is and that's something that the attorneys need to be aware of, that you're working with, and you're just I think I told you, you're setting up the alley-oop for the case to be slam dunked on the defense, because now we got all this consensus out there, these objective findings that are respected worldwide, not just in the United States. So yeah, and you have the chance to tell that story.
That's right. And it's a very easy story to tell once you're used to working it up. It's just a very easy story to tell. That's the thing that I like the most about it. Now, I guess the thing that I'd ask you is, like I described, if in the old days, everything was described as a lumbar sprain or a cervical sprain. And I describe a leg injury. If you came out with a leg injury and the doctor came out and said, oh, they got a lower extremity sprain, that's about the same specificity. Lower,
Yeah.
you know what I mean? So
Yeah.
obviously the extremities got different joints, different places that you could sprain or damage the ligament. Now you have to take that workup. In other words, if the doctor just says, hey, I got a sprain here, and they haven't definitively looked at the excessive motion, they don't know where it is, they don't know how bad it is, then that's where you're talking about the 4 to 8 week.
Yeah.
This is just a really undocumented soft tissue injury.
Now you go into confusion world, and that's what the defense wants. You don't ever want to be in confusion world. You want to be in specifics, objectiveness, and respected consensus on why you're there. Absolutely, and that's just part of the defense ploy. And confusion is what they want. They don't want specific. They don't want you to be so specific in your notes. They want confusion in your notes, is what they want. And that's why in the book, I talk about the chart notes. I know now, and when I wrote the book, I was more concerned about handwritten notes, because I advocate don't ever write your notes, because sometimes we can't read the handwriting. But yeah, you're going into confusion world with that.
Absolutely. So I'm gonna ask you a question, and it's like a rule of law. Don't ask a question when you don't know what the answer or the outcome is going to be, because it could go either way here.
Yeah.
One of the things that we promote, and I promote as the CEO of Spinal Kinetics, when I was a treating doctor, I used a company in Seattle, Washington for all of my excessive motion testing. And in those days, I probably could have drawn on x-rays and tried to do it myself, but I felt that the findings were so significant and that the consensus around these findings were so significant that I wanted it done independent. And that for me, there was a lot more leverage for me if I did it independently. So if I got the other doctor, the radiologist, to actually do the study, I just use the study results. So I promote that there is a lot of value to having these things done independent by an unbiased party that doesn't care how damaged they are.
Right.
Would you agree with that?
Absolutely. Yeah. Now, I'll take whatever I can to get the documentation, but yeah, the more independent, that's always the gold standard to go for. But I will take, if we don't have that luxury, we got to take what we got to take. But definitely, you doing it that way, taking control, taking responsibility, and using the consensus so you're not biased by having the x-rays digitized with the independent company or whatnot, is always the best way to go.
Right. Absolutely. So I guess the other question I have is, the easiest thing with personal injury documentation is you got to get all the injuries diagnosed, whether it's shoulder injury, head injury, spine injury, all the spine, wherever, all the injuries have to be diagnosed.
Even the injuries you don't even treat. Yes.
Correct. If they got seatbelt bruise and you're a chiropractor, you don't treat it, you at least have to acknowledge that it's there and diagnose, put it down, write it, code it, so it's there, so it becomes part of the record. So I've said, look, if you have house damage, the doctor is kind of like the estimator that comes in and says, hey, here's all the damage, here's the estimate of what it's going to cost. He diagnoses every single, all the drywall, the amount of square footage of drywall that's damaged, the carpet, the floor, the ceiling, and he lists out everything. If he doesn't list out everything, then you're not going to get the correct value for the actual damage to your house to get the house replaced. And in that case, the insurer knows, here's the labor, here's the cost, here's what it should be. And it's very similar in the injury world. You got, the more that you have all the injuries documented, then there is a degree of, okay, we know about what this is going to cost for physical therapy or chiropractic or whatnot. And then the next most logical thing, obviously, is you have to go, is there permanency? And that brings us to the impairment guides. So is there, you know, in your experience, and this is where a lot of doctors really have a hard time with attorneys as well, is there any other way to objectively document that an injury is permanent outside of the impairment guides?
In terms of documentation, no. This is again the gold standard to have a basis for the ongoing pain, discomfort, and the future medical care. And without it, you're then shooting from the hip. You can still do it. It's going to be more powerful that you do it at trial if you don't have it. But you're going to be able to get into the hearts and mind of the fact finder, whether it's a judge or jury later, or mediator or whoever, or if you have it, and you are communicating to that side how you're going to use it, whether it's going to be pre-trial or in trial. But in terms of having if you have the ligament instability documented properly, and you have the AMA permanent impairment documented 100%, that not only the case value is going to go up, you're going to have a basis for it to argue it because you have that. And so you're not, like I said before, you're not just shooting from the hip on the value. You're going into the future medical care underneath the guidelines. And if necessary, if it goes further into litigation, the doctor gets deposed telling that side of the story. Then you have a really good chance of getting a good number for settlement, which is ultimately what we want to do. No one's signing up to go to trial. It's not a fun experience for anyone. Defense fears it, just like the plaintiff's side fears it equally. You know, because there's a risk. We don't know what the jury's going to do. But with the appropriate documentation, it's going to be more solid if you have to go to trial that you have the AMA impairment and you got a doctor who understands that and can communicate that story to the jury to move that needle on the value, which is really what they're entitled to, instead of going back into confusion world where we don't really know. It's a soft tissue. We don't know. You know, you have it with this AMA impairment, and you get to tell the story of the AMA impairment, which is nice. You get to explain to the jury or mediator or judge why it's important, why it's used worldwide. So then they have a basis to say, oh, well, this makes sense that they're asking for this because he's permanently impaired at 40%, whether it's cervical or lumbar spine or wherever the injury is.
Right. Okay, I'm going to address another question that I think throws a lot of confusion into the market, especially on the doctor's side, for good doctors that don't like personal injury. Mm-hmm. Right? There are good doctors that just don't like that whole medical legal side.
Yeah.
And what I'm going to say is that you can have ligament injuries are permanent. You can have permanent injuries. You can have those permanent injuries cause permanent impairments. Right? But isn't it true that the value of the claim, the value of the benefit, says in the guides, the doctor's job is to document in a way that allows the adjudicators to, or the doctor's job is to document in such a way that allows anyone to determine the benefits the patient may be entitled to, any benefits the patient may be entitled to. So if I'm a doctor and I have alteration motion segment integrity, I treated that patient for 6 months and that patient has no chronic pain, they have no problems in life, they're at pre-injury status, they couldn't tell you a difference in their life of what they were from where they were pre-injury, which is my job. That's what I want to do. That's the results I want to have. Now, that reduces claim value. But do you as an attorney care about that? Do you care about that reduction of claim value?
Yeah, I do, because like you said, it parallels the value, the ultimate value of the case. So, and then there'll be a discussion with the client as to what they want to do, because ultimately they're the decision makers on what they want to do. So my job at that point is to tell them the pros and cons if we proceed further. But
right,
that's
but what I'm saying, but you as a personal injury attorney don't care if doctors get great results with patients.
I'm sorry, I didn't hear that. What?
No, you as a personal injury attorney, though, you don't care if the doctors get great results with patients.
Oh, yeah, right. Take them as I find them is what you're saying.
Yeah. I mean, yeah. Yes, it reduces the value of a claim.
Yes.
Okay, but you as an attorney, because doctors think that attorneys just want, it's a one size fits all. Everything's like super astronomically bad. And I'm saying good attorneys don't care.
That's right.
They don't care.
Correct. 100%, 100%. Yeah, and I would say most attorneys would agree with me on that. But there are some attorneys that you have to look out for that, yeah, you got to take it as you find it, because if you don't believe it and you're trying to feign some sort of value there, it's not ever going to work. It's going to come crashing down at some point in the process.
Absolutely. Absolutely.
Yeah,
Perfect.
like you're missing a important foundation in the house if that occurs, and you're moving forward, not respecting that.
Absolutely. Okay, so I guess the other question I have, since you've dealt a lot with injuries, I mean, I know as a personal injury attorney, if I were in the state of California, and I don't know where else you have licenses, but and you and I were talking about this earlier, if I were in the state of California, I don't care where I was. I don't care if I was in San Francisco. I don't care if I was in, LA. I don't care if I was in wherever I was. If I knew there was an attorney like you that understood the condition I was treating and appreciated the seriousness of the condition I was treating, today it's really easy to do Zoom calls and hook attorneys up with patients. I mean, you can practically do it right in the office, right? So, I guess the question I have is, how do you right now, doctors want to have attorneys refer to them. That's what they want to do. They want to somehow come to an attorney and say, hey, I have value. I want to enter in a relationship with you.
Mm-hmm.
How would you coach them on, one, how to do that, and one, make sure that they've got their game on, that they actually have something of value? Because doctors are a dime a dozen in the market.
Mm-hmm.
You know what I mean?
Yeah.
So, I promoted, hey, bring some value, bring not features, a whole feature set, some real value. My value I would bring to you is that you don't have to organize. My documentation is going to be stellar, and it's going to make your job a lot easier. But what would you communicate to the doctors on how to approach attorneys so that they can get better into relationships with those attorneys?
Oh yeah. So because of COVID, I would say pick up the phone, call the lawyer that you're thinking would be a good match for your for what you do for the patient and documentation, everything we're talking about here today, and then set up a Zoom call so they can meet you face to face on the video, and just 5 minutes, tell them why you're different and how you approach soft tissue, and why ligament instability injuries are very vital to your practice in terms of documentation, and how that helps the attorney argue their case later. And then you'll know within that 5 minutes whether or not it's going to be a good match, because you're gonna hit on an attorney that gets it. There's a lot of them out there. Don't believe they're not. You just got to find them in your community, and then just start that powerful relationship. And the thing is, I've had doctors say, well, if we get too cozy, is that not a good thing? Here's the thing. The ultimate decider of value on an injury case is going to be the jury. And if you're really close with the doctor and the defense tries to bring that up as some sort of nefarious relationship, you get that all worked out in jury selection. So I always tell a doctor, look, we're going to be honest with this, because we're trying to do the best we can for the patient. The patient
Right.
is the focus. If I know this doctor is very detailed in documentation and they live close by and they treated them, and I work with this doctor a lot, I'm going to let the jury know, hey, that's why we did what we did, because we wanted to be able to show this story of the injury the best way possible. So so going back to what I was saying, pick up the phone, do a Zoom call, do an office tour if you want. Once this COVID list, say, hey, come into my office. I'm gonna show you. Let me do a 5-10 minute tour of my office, and I'll show you exactly what I do when I document ligament injuries. That's another thing you can do as well. And I know attorneys like seeing the offices of the doctors too, and how organized the doctor is, because we talk about that sometimes. So that's something you can do too.
That's good to know.
Yeah, we go, oh yeah, he's really good. He's got a sharp practice. He got the room for this, room for that. He has X-rays on site. He has X-rays outside. Whatever it is. Yeah. So that's kind of my 2 cents on that.
Okay, another question that I just thought of, and it's basically just because I got you and you've been not that you're so hard to get. It's just busy schedules. I promoted. Look, ligament injuries have two imaging biomarker findings. And biomarkers are anything that is in the body that definitively defines and makes a definitive diagnosis. HIV in the blood, HIV diagnosis. Bone fracture on imaging, bone fracture, definitive diagnosis. So in imaging, there's two imaging biomarkers. There's excessive motion, which I have said for the longest time is the worst problem, and there's disc herniation. There's 220 ligaments that hold that spine together, only 23 of which are discs. So there's been this over heavy reliance on MRI. And I don't mind MRI as a tool, but these doctors oftentimes are dealing with attorneys that will tell them not to excessive motion test, that they only want an MRI. Right? And I'm sitting there going, MRI is so limited. I mean, it's cranial cervical junction limited. It's so limited. And so any advice on how to overcome that when they hit that from an attorney?
That's tough. That tells me that attorney's grained in their ways. They've been seasoned for a while and they're doing one thing one way and they don't want to change. It's a little bit, but yeah, that's tough. I've been trying to figure out a way, not only for me to meet other like attorneys, but also for doctors to, find out how to do that too. Because a lot of times when I meet with doctors, they want to know, hey, how can I? This is a very popular question. I don't know if there's any cure for that, because once they're set in their ways, it's kind of hard to say, hey, you got to do it this way now, and you're doing it on an X-ray or flexion extension, not the MRI, right? But that tells me the attorney doesn't understand the importance of the ligament instability, the laxity, and why it's so valuable and how it can be so valuable. And he doesn't have experience enough with, a lot of the attorneys want, that tells me the attorney just wants all the big cases. Yeah, we all want great cases, but you got to get, there's a lot of smaller cases, the soft tissue cases they call it, but they're not really small because once you have it appropriately documented, the value opens. You just have to, do your homework to get there. There's no free lunch and all, everything we're talking about, there's no free lunch. This is, trained, yeah, it's trained medical skill.
Yes.
Is what it is. And communicating that is those two things. But if the attorney doesn't want to do it, the attorney doesn't want to do it.
Totally. Mark, I'm going to send you, you're going to see this. I'm going to send you this because it's a small booklet that I wrote about MRI and the deficiencies in MRI, not because MRI is deficient, but it was never designed to pick up some things. And doctors on the program today, if you want a copy of that, you would just call in, we'll get your email address and we'll email you a copy of that, because that's something that's been fairly helpful for the doctors to use for attorneys that want to know, that want to understand. I mean, the biggest thing you got to do to change is you got to want to change. You don't want to change, it's pretty hard to change somebody.
And that's another selling point you could do with the attorney is just that, about how the MRI is different by getting that, and setting yourself apart that way.
Correct. Okay, Mark, I tell you what, time-wise, unless you want to bring up any other topic, I kind of like to go to question and answer and see if any of the doctors or anybody on this call has any questions. So I'm going to go to the question box real quick and see if. Okay, so this doctor's asking you, what is the case value increased with the impairment? What is case value increased with a permanent impairment? Which you and I are both going to say, hey, that it depends on a lot of different factors. But go ahead.
Oh yeah, it really does. But just off the bat, 15 to 30,000 could be the difference on a soft tissue, what they would call a soft tissue. What would be called a soft tissue case in the beginning, meaning just muscle, nothing touching on ligament, bone, or nerve. Yeah, 15 to 30,000. So one case, what we have.
Say that again, Mark. Say it again. So
yeah,
what?
It could be $15,000 to $30,000 difference on an average case, doing what we're talking about for the patient.
Yeah.
One case, it was a soft tissue case that came in, but we had it appropriately documented with the impairment. And I think this one had both the cervical and lumbar at full max, 45%. That one's that one sold for $60,000. Now that would have been, if you didn't do all this, then that would have been a $15,000 case. So,
right.
So I don't know if that provides some insight, but I don't want to. There's no hard line number because there's so many different factors. I mean, there's pre-existing factors. There's biomechanical factors with property damage to the car, age of the patient. So you have to have a lot of stars align. But let's look for those stars. Let's not look for the stars. Let's look for them. And if they align, then you're doing your job for your patient, and the attorney's doing their job for the client.
Absolutely. I'm just looking at, I'm looking at, now the questions are coming in.
Okay.
Absolutely. Okay, perfect. So, okay, so I'll answer this. This doctor says, what's the best way to approach impairment rating if you don't have any official training on it? Impairment rating is so simple to learn. You either take a course on it, you call our office. We have a course. I have a course that I offer that teaches it. Impairment rating. And Mark, you're an attorney. How long did it take you to really understand DRE impairment ratings?
Well, and I'm not saying I'm an expert in the knowledge area of it, but there's a lot of resources, especially today. There's a lot of resources online. You can just Google.
Correct.
10 years ago, when I wrote the book, it wasn't like that. But it doesn't take too much effort to get to the level. And if all else fails, if you don't do it, call the attorney and say, look, I'm thinking this case, we have lost motion segment integrity. We need to get it verified with an AMA. I happen to know a doctor that does it. What do you think? And approach it that way.
Right.
Just turn heaven and earth to do what you can. And we're not looking for perfection, but we're looking for competence. So that's pretty much, if you got a clear-cut case that needs to be documented underneath the guidelines, just do what you can to do it. Do what you got to do. And I explain to the clients, look, they're gonna do some measurements on you, but this is why it's important that we do it, because this is the gold standard that we have to argue.
Well, it's how you determine the severity and location of a ligament injury.
Right.
I mean, it's just that simple. There really isn't another way to determine the severity and location of a ligament injury.
Right. And without that, you're just then you're going to succumb to the confusion of the defense. And now the doctor and the lawyer are with a muscle injury case. No,
right.
It shouldn't be that way. Like you said, there's a ton of ligaments, longitudinal ligaments running down that spine, stabilizing the entire body. For God's sakes, that's important.
Right. Right. Okay, here's one for you. We hear a lot from attorneys in California that soft tissue injuries are not recognized in California. Is that just an example of an attorney that's not familiar with these types of injuries?
Absolutely, 100%. That is a fiction, maybe from a lawyer that just doesn't want to rise to the challenge to know that there's homework involved to do their job for their client. Ultimately, like I always say, the ultimate value decider is the judge or jury, but let's make that job for the judge and jury as easy as possible with the medical documentation that's available to us underneath these guidelines.
Perfect. Okay. Okay. So here's a question. The doctor says, how should you answer defense response when you've released the patient with a 25% impairment from alteration motion segment integrity and haven't seen the patient in a year or two regarding how the patient is functioning today? Defense attorneys seem to minimize impairments since you haven't seen the patient in a long time.
That's okay.
Yeah, go ahead.
No, that signals to me lack of preparation from the injury lawyer, because if you're getting that close to in the process, I'm always going to reach out and have my client go back to the doctor for a review. That way, if they're ever asked, hey, you hadn't seen him in a year or two, that answer never comes out. It's always, oh no, I saw him 2 months ago, X, Y, Z. But if you're in that boat, then you just honestly answer it. Say, look, I documented an impairment based on X, Y, Z a year or two ago, and you know what? It might be a good time to see him again. So you just you flip it, turn it around, and say, you know what? That's a great point. I'll probably be giving him a call to see if he can come in for a re-eval.
Perfect.
You just flip that right on them.
Totally. All right, so I got another question here. It's a great question. Explain the best way to address the insurance company's objection. So adjusters will object to this study. Hey, we've never seen it before. We don't know what it is. This is something really outrageously, like we've just never seen this before. We get that a lot.
Simple. Then the attorney needs to file a lawsuit and let them examine it more closely in discovery.
Perfect, because it's like been around for 25 years. It's been
If they're
around forever.
claiming the put up, shut up defense, then you put up, so they shut up, and then they can evaluate it from the facts, because that's what really what you're doing in your chart notes. These are medical facts based on opinions that you have based on objective assessments.
Right. So I guess the question, Mark, in all the time and that you've been doing this, can you imagine an insurance company that has not seen this study before?
Oh no, the AMA impairment?
Well, no, an excessive motion study on X-ray.
Oh no, yeah, they're not as common. Is that what you're asking?
Yeah. So what the insurance adjusters will say is, oh my God, in all the time we've worked here 20 years, I've never seen a test like this.
Yes. That's so. Well, here it is. Well, great. This is a great opportunity for you to learn about it, so we can show you why the patient is suffering the way they are.
Correct.
Or why the therapy has extended past what you consider the guidelines.
Well, the other thing is sometimes defense attorneys will ask doctors, well, why did you do this test?
Oh,
and all of a sudden the doctor feels like they have to defend. My response has always been to the defense attorney, how else would I get this information?
Exactly. You're flipping it. Yeah. So you're polarizing their question there. Yeah. How else am I able to do it objectively?
Correct.
Oh, by the way, this is the gold standard of objectivity with a ligament injury, let's say. You can't argue with that. And it sounds reasonable and actually very empowering when the jury hears that.
Absolutely. The other thing, go ahead.
You guys, the doctors you're the empowerers. You're the ones, your chart notes are the boxing gloves for everything. And I just want to throw that in there.
Yeah. Well, I tell you what, Mark, because it brings up a question I get asked a lot. And I've done depositions and I've trained doctors on depositions, and you can query the attorney's question, right? So if I don't totally understand your question, some doctors think you can't ask the defense attorney any questions.
Oh, yeah.
Right? So you can query a question. If somebody says, hey, why did you do that? I can answer that question with another question. How else could I have done it?
Beautiful. That's a nice way of doing it. Yep. You definitely can. And when you query the question, it shows that you are trying to provide the correct response. That's important,
right?
Especially being videotaped, so they'll see that that ever comes into issue, or if they ever play that segment or talk about that segment in trial, it sounds really good because it's the truth. Look, we're coming from truth. We're not coming from the darkness of confusion. We're coming from the open light of truth, and any juror is going to resonate with that, or judge.
I love that.
Yeah.
I love that. Yeah, I'm going to use that. I love that.
Well, the defense wants to keep you in darkness. They just don't want you to be so great with your notes. They don't want to be so great with your answers, so confident, so empowering with your answers.
Right.
And they're hearing answers that they never really hear a lot about, right? They don't hear about impairment all the time. They don't hear about instability of the spine and why it's weak. These are things that sets you apart. And when you set yourself apart, people pay attention.
Absolutely. All right, so I got another question, and we're good with time with you. I got you. I don't know what you got scheduled. We're 44 minutes into it. You still good?
Oh, good. Yeah. No, whatever you fellas need.
Okay. After discharge of a PI patient following MMI, can I continue to treat the patient for retaining care and estimate that bill in the settlement up front?
Yes and no. Just gotta be careful with that. MMI, I'm a little bit cautious on, because unless there's a permanent impairment to a particular body part and you're adjusting other areas that are not permanently impaired, but MMI is confusing. I'd much rather have you put in your chart notes that I'm releasing the patient to participate in their own recovery. That's more powerful because now, keep in mind, you may not be the only doctor treating the patient. So that's my answer to that one on medical maximum improvement, MMI. In the
Good.
chart note.
So for the doctor's language, it would be patient return is needed in order to participate with their own recovery.
Yep.
And that you would have active care instructions that would the patient could actively do themselves, which means that they have ongoing care for their own condition.
That's correct. So the active care is everything the patient does. Passive care is whatever a doctor does. That's correct. And that's
Okay.
important. That's a distinction. It's an important distinction because that's what if you're selling the case prior to filing a lawsuit, Colossus looks at that. And then also when you're doing your passive care as a doctor and you're prescribing active care, you want to make sure when you're seeing the patient in your office visit that you're documenting or asking the patient whether or not they're doing the active care that the doctor prescribed. So you're getting both benefit of the active and passive care in the visit. Does that make sense?
Yeah, totally. Absolutely. Plus the other thing, doctor, you're empowering the patient anyway. You're more active care you get them involved with, you're empowering the patient to be causative over their own life, their own condition.
Yeah, at the end of the day, what you're doing as a doctor is empowering the patient to become responsible for their mishap and the injury and whatnot. That's exactly what you're doing.
Yeah.
You're a way shower.
Okay, so I'm going to take a stab at this question because I don't totally understand it. But Mark, I think what the doctor's asking is when should you document LOE or DUD findings? Like I said beginning and end, but what would you say?
Oh, it's lost enjoyment of life, and is that was the question?
Yeah, well, yeah, the LOE or the DUD findings.
When should you document that?
Yeah.
Yeah, as soon as possible.
Right, but then you also want to track, especially like on a DUD, you could have a DUD in the beginning that 6 months later is no longer there.
That's right. That's right. So you want to, yeah. So if that, you have to just document that if that's the case. And of course, if you have an impairment rating, the DUD and LOE is even more important, right? So yeah, you take each case as you find them, and if there's changes in that, you document. Just document that change.
I think what this doctor's asking though is it good enough to do it at the beginning and at the end?
Oh, I see. That, as long as it's documented, I haven't had that come up as really defense points, particularly at the timing of it.
Okay.
Yeah, the timing is not as important in terms of where the case ends up with any impairment rating. So does that help?
Yeah.
Okay.
Yeah. Okay, I'm just
yeah. No, we're good. That was my answer on that.
This is a question, and this comes up because there are, and I have a problem with this, but there are trainers out there especially in the chiropractic profession that say, hey, if you have this condition, the insurer automatically is going to pay $50,000 or $75,000 out, and that they automatically have to establish a reserve for that amount. So if you had a fracture or if you had alteration motion segment integrity, you had this or that, they automatically have to reserve for that. Have you run into that? Is that true in your world?
Yeah, it's very secretive to get behind the scenes as to what the insurance company is doing with setting reserves. I've tried to get conversations with adjusters on this. And it's almost like trying to figure out the game that you're playing without being allowed to see the rule book. So the better way to do is to take control of what we can control, which is what we're talking about here today, and just move forward. And get away from overthinking. That's why I was a little hesitant on the last question about how much difference in value will it be.
Yeah.
I just kind of let's just move forward with what we can take control of. But
correct.
Yeah, I haven't run into that too much to have any insight to really give a good response on that one.
Yeah.
It's important if you know it, but I would much rather just move forward with helping the patient and client with documenting why they have so much pain and discomfort, and 7 months post collision. There's no broken bones, but we got laxity or whatnot in the body.
Yeah, well, for us as a company, I mean, we want early accurate diagnosis.
Yes.
So the patient can have better permanent recoveries earlier, more cost effectively, less expense, less time. That's a whole purpose of our company.
Yeah, and I say in the book, you should assume if the care goes beyond 3 months, you should assume as a medical provider possible motion integrity or ligament laxity until it's ruled out. And if it's ruled out, it's ruled out. And not every case is going to be an impairment case. You know, we're not here today saying, oh yeah, you do this, you get it. No, we're going objectively on your skill and experience as a doctor and on the subjective complaints of the patient, combined from what you see in your analysis and your treatment of that patient. So
Absolutely.
I just want to clear that up in terms of what we're doing here.
Absolutely. So, Mark, I don't see any other questions coming in.
All right.
I really, really, really appreciate you taking the time to do this.
Oh no, thank you for setting it up.
Yeah, well, it's just nice. I mean, you and I were talking about how far back we went.
Yeah.
You know, it's been, like I said, when I read your book the very first time, I was like, oh my God, I wrote a book on this chapter, but he wrote it. He actually did.
Yeah.
So it was just, I've just personally benefited from your work, both directly and indirectly for as long as we first met.
Oh, I appreciate that. I'm standing on the shoulders of giants, you know, people who documented this before me. So I'm just trying to put it in.
They never put it in a book.
Yeah.
They weren't giant enough to get it in a book.
Okay.
So yeah, you know what I'm saying? That to me, that's, oh wow. So like I said, I really appreciate your time. We'll let you go at this point. Doctors, if you want a copy of the 3 biggest pitfalls with MRI and spinal ligament injury diagnosis, just call Spinal Kinetics. I'm going to put Spinal Kinetics number up here. Just call Spinal Kinetics. If you aren't actively spinal ligament injury testing right now, again, either go to www.thespinalkinetics.com and put in a request. One of our people will call you, and we have excellent doctors and staff with this company. Or you can just call us at 877-508-9729, and we're going to get your email and we'll send you out a copy of that. Mark, thanks again. Doctors, thank you for taking the time to watch this. And as always, we look forward to seeing you on the next webinar. Thank you.
Thank you.